Is it Mr. Skiba?
Skiba, correct, Your Honor.
All right, your argument?
Good morning, Your Honors. May it please the Court. John Skiba appearing on behalf of Lizette Venslake. Your Honors, the issue here with the underlying court, with Judge Warner, this is really a matter of reliability. How reliable are these statements that Midland Funding submitted, the Chase Bank statements? Now, Chase would have the court reduce the rule down to really two prongs. Basically, if they have possession of the documents and they have someone, not even someone from Midland Funding, as was in this case, someone state that the documents were relied on, that they are per se reliable. And if we take that out to its natural progression, I mean, the fact that they're stating that they're relying on these documents, to which their witness testified they had no background knowledge as to how Chase Bank kept and maintained its records. They had no information how the documents were even transferred from Chase Bank over to Midland Funding. That doesn't speak to the reliability of the Chase Bank documents. I mean, frankly, it speaks to the negligence of Midland Funding in relying upon them, to rely upon documents to which you have no underlying knowledge.
Counsel, I understand your argument, but I've read some of these federal cases, and there's some pretty broad language in those federal cases. I know that that's not binding precedent on us. What would you say about that?
I would say that almost without exception in the federal cases, there is this third prong, this indicia of reliability. There has to be something else. There has to be some testimony or something that gives the court some comfort that what they're receiving is reliable and accurate. And we saw that in State versus Parker. Judge Downey pointed out that the basis that the court made its ruling and found it reliable, they found that the Capital One employee who was testifying about Capital One documents was able to, testify that Capital One regularly made these documents. She was able to describe the transmission process from the vendors, and she was able to testify that these were normal business records of Capital One. That's something that we didn't have here. We had an employee from Midland Credit Management, Inc., a non-party, trying to testify on behalf of the plaintiff, Midland Funding, LLC, for documents that were created by Chase Bank. So there was this comfort that the Supreme Court could get in the Parker case, in that they had the person there who was creating the records. And I'm not arguing that it has to be the specific person in every instance who created the document, but clearly they were influenced by the fact that they had someone there who was at least familiar with the underlying processes, which we didn't have here.
So what's a average trial judge to do? They get hundreds of these motions for default judgments. They don't have the benefit of the case going to trial and having a live witness. And they've got affidavits attached from Midland. Midland does a lot of collection work throughout the state. What does the trial court need to have in an affidavit where it can admit and accept those credit card records? Usually it's just a statement or two that's got, the past due account. Usually there isn't even the original contract that's attached. It's just a statement or a few statements. And these are records from Chase or some credit card company, a lot of them. They've been turned over to a third-party collection agency like Midland. What does a trial judge need to see in that affidavit so that she can believe that the documents are authenticated and admissible under the business record exception?
Your Honor, we need to see an affidavit, that at a minimum meets the requirements of Rule 8036, that goes through those specific requirements and has the documents attached stating that at least reviewed those. The problem that we're getting is we often get...
From the current institution that's the party, or from the prior institution where they were originally created?
From the original creditor. Because that's where I think the reliability issue comes into play. We have a case like this one where you have a witness who frankly knew nothing of the original creditor's business practices, and frankly even conceded she hadn't even reviewed these documents prior to trial in giving her testimony.
Did she testify that Midland keeps these records in the ordinary course of its business and relies on them?
Well, and Judge Warner addressed that. In his ruling, he stated, in his words, she had parroted the magic words of Rule 8036, but his finding was that there was nothing to support that. She had conceded time and again on questioning from myself, from the court, and even from her own counsel as to her knowledge of how Chase Bank keeps and maintains its records, and she didn't have any information or any answers. So the mere fact that she had stated that the court said wasn't persuasive. There had to be some kind of substance behind it.
If you'll allow me another question here, what about these statements in paragraph 33 of Parker, where our state Supreme Court said trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. And then it cites the Adafinte case and describes it as listing cases that permit business records of one entity to be admitted as a business record of another entity if the latter entity relies on the records and keeps them in the ordinary course of business. That certainly does not seem to require something in this case from Chase.
I think that, Your Honor's quoting from paragraph 33 of that decision. I don't think we can read paragraph 33 and not review paragraph 31 as well, right, where the court specifically said, the last sentence of paragraph 31, these facts qualify the entries in Ward's report as business records. So the court's saying, and if we look at the beginning of paragraph 33, it seems the issue raised was, do we have to have the actual person who's created these documents, who was involved in the preparation of them? The court's saying, no, we don't. The courts regularly will admit documents, but there has to be some underlying basis and understanding of the underlying processes as far as how they're put together. And that makes sense because, as Judge Downey pointed out, if the court was to adopt what Midland Funding is proposing today, it effectively guts Rule 8036, and it really has no meaning. If the only thing that's required is possession of a document and saying that you rely upon it, and then it comes into the court, what one could see, as the court has pointed out, that the problems that could pose in many different areas.
I agree that it would gut the written rule of evidence for the business records exception, but isn't that what our Supreme Court has done in Parker?
Well, and let me weigh in here because, I don't read that language in Parker the same way. I'm interested in your take on it because trustworthiness and reliability stem from the fact that Capital One regularly relies on the information that third parties submit as part of their ordinary course of business. That means that Chase submitted as part of Chase's ordinary course of business. And as I read Judge Warner's ruling, that's the missing link here. There is nothing to show that Chase submitted any of this as part of its ordinary course of business. That's how I read Parker. I don't know that there's any other reading of that sentence.
Correct. There is nothing that Chase has provided, and when the witness for Midland Credit Management was asked that very question, she had no guidance either. She had no information as far as how the documentation was transferred from Chase Bank to Midland Funding.
And that's what gives it indicia of reliability, such that, hypothetically speaking, if there had been an affidavit from a Chase custodian of records saying these are Ms. Van Slyke's credit card records, we created them in the ordinary course of business, we've sold this account to Midland, doesn't even have to say all of that, but something to show that Chase has created and submitted these records as part of its ordinary course of business. That's what I read Parker as requiring.
And I would be in agreement with that because otherwise simple possession satisfies the rule, right, which is problematic. And it's interesting because the way that this rule is applied in this case, we've actually reduced the bar as compared to what Chase would have to testify to if Chase were sitting in that courtroom testifying about its own documents. It would be held to the standards of Rule 8036. But for some reason, we're saying that the bar should be lowered dramatically as to a company, a third-party debt buyer. Particularly, we have a witness who's two companies removed from Midland Credit Management, Inc., testifying on behalf of Midland Funding, LLC. And so, again, Your Honors,
would it be sufficient if the custodian from Midland included in her affidavit that she was familiar with how Chase keeps its records, how it compiles its records, and is aware that those records conform with, government standards, whatever applicable standards are, and also that she, on behalf of Midland, regularly receives those records and they incorporate those records from Chase in their business records? Would that be a sufficient link?
I think that that's going in the right direction because I think that's what happened in Parker. Ms. Ward was able to testify about those underlying steps as far as how the vendor's documentation came to Capital One and then how she compiled those documents and created her own record.
So you would concede perhaps you wouldn't need a separate affidavit from Chase as long as the person in Midland, for example, the third party had a familiarity with how those records were kept and could establish a foundation for how she was aware those records were kept at Chase or whatever the company was you're receiving the records from?
If the witness is able to provide some kind of foundation as to how the documents were created, that they at least address the elements of 8036. If they're merely being able to testify as to essentially what filing cabinet this is stored at Midland Funding, I don't see how that gets over the issue of reliability.
Why wouldn't it be just as easy for a company like Chase when it sends these records out, and counsel, I'm sort of throwing this in your direction as well, to, when they send the records out to Midland, include an affidavit from a custodian of records saying these are our business records that we're submitting to you? Wouldn't that be a pretty easy thing to do?
One would assume that would be easy, and one would think it would be equally as easy. These witnesses are routinely granted telephonic appearances in the court. Why can't a Chase witness call in on the telephone as well to give some comfort as to the reliability of the document? Because what this does, as these are admitted, it effectively eliminates any effective cross-examination by the defendants. Because we have a witness who has been allowed to lay foundation for documents they have no understanding of, and yet it puts us in a position where when we ask that witness questions, they don't know, but the document has already been admitted. It also deprives the court of any rational basis on which they can base the trustworthiness of the document or the reliability of the document if we don't have additional information other than, yes, we have the document and we've relied upon it. So based upon that, Your Honors, in conclusion, essentially and the court's brought up great questions as far as why don't certain things happen. And I think it's because Midland Funding would like the rules of the court essentially to adopt to its business practices.
I don't think that's true, counsel. I think they're confused. I think they're getting a lot of different direction from federal courts, different judges. They really just need to know, what do we need to do? And I think in fairness to them, it is a little confusing to them. So I guess I'd disagree with your position a little bit there. I understand what you're saying, but
my main point is we need some kind of indicia of reliability for these documents. And this case is a glaring example of how little the lower courts get. We get witnesses who really don't know much about anything related to the underlying process.
I think that applies to every case I ever sat on as a trial judge.
Okay.
So,
all right. But I don't have anything further, and I thank you, Your Honors.
anything, counsel? No. All right. That's a joke for the record. That's not true. All right. Thank you, counsel. We'll take this matter under advisement, and we'll issue a written decision in due course. Court's in recess.